Good day, everyone, and welcome. My name is Dan Sampaio, and I'm delighted to open today's Mondaq webinar in association with Alvarez and Marsal, discussing investigations as a key to good governance in the Middle East. We are joined by an excellent panel to take us through today's session. James Daniel heads Alvarez and Marsal's Middle East disputes and investigations practice in Dubai. He specializes in complex fraud and corruption investigations for government and private sector clients and advice on the prevention of financial crime. Steve Spiegelhalter is a managing director with Alvarez and Marsal's disputes and investigations practice and is the North America investigations practice leader. He specializes in investigating alleged political corruption, money laundering, bank and wire fraud, false claims and other alleged criminal activity. Adam Vors is a partner at DLA Piper and advises major corporates and financial institutions on a broad range of large commercial disputes, with a particular focus on fraud, asset tracing, compliance and investigation matters. Adam is co-chair of DLA Piper's Global Investigations Group. And completing today's panel is Ali Anwar. Ali is a managing director and the Middle East practice leader with Alvarez and Marsal's Global Transaction Advisory Group in Dubai. His core expertise is advising sovereign wealth funds, global and regional private equity firms, multinational corporations and family offices on M&A and capital market transactions as a financial due diligence advisor. Now, before I hand over to our panel, a housekeeping item. The team are keen to encourage as many questions from the audience as possible, and we will endeavour to answer as many as possible during and after today's presentations. To submit a question, you are able to use the questions tab on the right-hand side of your page. Today's session will also be made available on demand. It's now my pleasure to hand you over to James, Steve, Adam and Ali. Thank you.
Thank you, Dan, and thank you to the Mondaq team for helping put this together. Good morning, afternoon, evening, everybody. So I'm just going to briefly set the agenda for today. We want to make this a sort of a free-flowing conversation. As Dan said, please do submit your questions on the chat, and we'll try and address this as we go along at the end. So we've got a pretty diverse audience, and I hope and a diverse panel to match. We've got a transaction specialist, a lawyer, and a couple of investigators, one from a regional perspective and one from the US perspective. So feel free to ask questions to any of those, to any of us or to us collectively. So we kind of want to cover four main areas. First of all, we thought we'd sort of set the scene and discuss some of the major themes in the market, some of the ambitious targets that the region has for growth and specifically for diversifying away from a relationship oil-based economy to a real economy, and what that means for governance. Then we'll try and talk a bit about what we've learned, what we see in the market, and what needs to be done from our perspective to enhance governance to enable these ambitious transformation plans that we have in this region. And if we've got time at the end, we might touch on some of the legislative changes that are being put in place to enable this transformation. So, Ali, can you sort of kick us off by helping set that scene and kind of start that discussion on what the major themes are in the market?
Thank you, James, and thank you, Mondaq team, for putting this together. Look, today, 2021, I think, not just in the region but globally, just from a deal flow and investment perspective, it's been, the biggest year ever, and there's no signs that it's going to stop. So the region is really taking part in that bonanza, both from a global investment perspective, sending capital out of the region and also attracting record numbers of FDI into the region. I would love to talk a little bit about what's driving all of that and how does good governance become a key part of that story. You know, we've been talking about moving away from oil for many years, and you know, I've been here for 11 years, and that's the first thing people talked about when I moved to the region in 2010. But the level of activity that I've seen in the last 2 or 3 years, you know, nothing's really matched that since. So what that really shows is the level of investment that's going into developing teams in sovereign wealth funds, who are now essentially the vehicles for the government, especially in Saudi and the UAE, to really not only develop their investment portfolios globally, but also to invest locally. And that's a big change that we've seen in the region, and that's all, you know, linked to accelerating that diversification away from oil, and really making our economies, you know, something which are much more competitive at a global stage. You know, I do a lot of my day-to-day work in diligence, and I've seen it firsthand that a lot of the focus now is you know, on the management teams, on the quality of the teams running the assets that investors are going into. The corporate governance is a big topic now. ESG, of course, is driving a lot of that. And I guess, you know, one of the things which has driven that trend is also in the past, because of poor diligence or maybe hurrying through the transaction, a lot of investors, including sovereign wealth funds, have had their hands burned, where they've invested into companies which they then found out were subject to frauds and other things that management were taking part in due to lack of good corporate governance. So a lot of lessons have been learned, and you know, we really are now in the position where I'm seeing it firsthand that diligence is a lot deeper now than it used to be in the region, which is great to see. And you know, if you are going to monetize local assets by attracting FDI, you know, from institutional investors abroad, it becomes a big topic for international investors. And we've seen the ADNOC pipeline deal. We've seen, you know, many you know, multi-billion-dollar deals in the region in the last couple of years, where, you know, we've managed to attract a lot of the high-quality institutional investors, and for them, corporate governance in the region is high on the agenda. So you know, we've had some bad press as well, like the NMC case, like the Abraj case, and there's many other examples we could give. You know, so frankly, we have had to do a lot of work in the region to really make ourselves a lot more attractive to international investment. But I think we're on the right path, and this discussion today is very exciting to me, because it really is one of the hot topics these days.
And Adam, can you put a little bit of sort of flavor on some of, if we look back a bit, what have been some of the issues or that have sort of undermined good governance that you've come across with your 15 or so years in this region?
Thanks, James, giving away my age there. I think I'd flip it around a little bit, to be honest, because we're talking here about good governance, and I think my experience of the time I've been in the Middle East is that it's the poor governance that's really brought the work for the lawyers and the consultants, because it's only been, in my experience, probably the last 6, 7, 8 maybe years that companies have really started looking at the benefits of proactive good governance and how that can improve their position. And that's improved their position, just as Ali was saying, in terms of from the transactional side. What organizations need to have one mind on is when the PE fund wants to exit and they need to sell, or when there's an M&A opportunity and there needs to be a buyer coming in and the due diligence needs to be done. If you don't have the good governance in place, then it's almost instantaneously a no-no, because for a large part of the world, operating in the Middle East is seen as high risk, and it's seen as high risk from a compliance perspective because of perhaps the historic way that transactions were done, the historic way that companies operated without so much of the types of controls and systems that you see in perhaps more developed economies. So the types of things that I've tended to see, and they continue to proliferate now, are organizations that have historic contracts in place, particularly supply chain issues, but also issues with third parties that they're working with in other aspects of the business, whether it be joint venture arrangements, whether it just be getting in services or getting in goods that they need as part of their business operations. And those contractual arrangements have been in place for many years, but the companies have not done any form of due diligence on their third party. Looked at some of these contracts for 10, 20, in some cases a lot longer than that, numbers of years. And those types of issues create very significant risks for an organization if you don't really know who you're working with, you don't really have up-to-date protections that you can put in place in your contractual documentation. That's not the be-all and end-all, but you can do a lot of things proactively to try and shift the risk from being a reactive, we'll just push it away and hope nothing will go wrong, to okay, let's get ahead of ourselves here. Let's get comfortable, so we're not going to be in a situation where if we want to get FDI, if we want to sell, if we want to contract with a new third party, we're going to be chasing our tail and being reactive at that stage, because most of the issues have been around poor systems, poor controls, which have led to various forms of fraud, corruption, accounting irregularities, you name it, they're all documented. I mean, I can go into specifics, but I think that sort of sets the scene from a legal perspective.
Yeah, we had a question before from the audience, which was around. It was really a question around culture, and how do you? It talked specifically about the 3 lines defense model in assurance. How do you implement that effectively in a world of driven by a cultural environment, driven by relationships and networks? And I think that that's the challenge that a lot of people will be facing, is adapting, implementing your governance structures, but in a way that is used effectively with that cultural norm. And so, how do you actually, rather than just have a set of policies and procedures, how does the culture transform itself to adapt to those? And I think this really gets to the crux of the discussion, which is transforming from that relationship-based model to a rules-based model. I think in terms of the 3 lines model, we're getting a bit technical already here, but in terms of the 3 lines model, it's really about assigning risk at the appropriate level. And it's really about devolving responsibility to the appropriate levels, and then having checks and balances in place to monitor, to test implementation, and not succumb to the bypassing of those governance structures by stakeholders, senior management, which has been, I think, a key issue underlying a lot of the problems that certainly I've seen in this market. So it's a challenge, because it's really a question of cultural transformation, not just about changing some of your procedures and your basic business processes. It's about a cultural transformation to then live by that set of rules, as opposed to the relationship-based approach that has been that we've had up to this point. So I think that's a real challenge to being successful in transforming the economy. Steve, what do you, from across the pond, what sort of perspective can you bring on this? And you've done some work in this region as well. what sort of perspective you can bring in terms of the historic issues that you've come across?
Sure. So really quickly, my background, and so a lot of what I'll say comes from that background. I was a prosecutor with the Department of Justice in the United States for 8 years, including 4 years in the Foreign Corrupt Practices Act unit, which is the unit that prosecutes all transnational corruption for the United States government. And it's because of that statute, which includes a provision that says you can't bribe someone, but also includes provisions about the books and records being accurate and controls being sufficient to avoid bribery. That unit really has been very focused on compliance controls, especially in the context of foreign direct investment, in the context of M&A in various regions of the world. And I can tell you our perception when I was at the department was that it was very risky to do business in the Middle East. A lot of our cases stemmed from the historical relationships that Adam mentioned a little while ago and sort of the perception of how business gets done. And, you know, I have had several cases there. I've had a lot of investigations there. And the issues that pop up over and over again really do have to do with how business is secured. It's very relationship based in the Middle East and in other places, by the way, China, India, Russia. It's not unusual necessarily, but it is definitely a model that lends itself to potential problems. And so the US government has been quite focused on the region for a long time. I would say that, you know, from the perception of the US government, the way to sort of deal with these issues is very governance based. So I think the topic of our conversation today is very helpful. You know, talking about managing risk at the appropriate level of management, implementing internal controls that are sufficient to avoid all of the issues that arise especially when there is an M&A deal, being prepared to do investigations. But I can tell you from the U.S. government standpoint, and then from the standpoint of what I do every day, there's an expectation now that if a U.S. or Canadian or European company, and I think that the Department of Justice has had significant impact, and the SEC, U.S. SEC, have had significant impact on the mindsets of European regulators, but then also European business people, and also in Canada and the United States. There's an expectation that there is a review done for potential violations of U.S. sanctions, U.S. tariff finance laws, and the corruption laws. And so I think that you know, the advice we give to our clients is to get out in front of that. Obviously, better to have an operation that has looked at that in advance and doesn't wait for a hostile set of lawyers, or not that Adam would ever be hostile, but a hostile set of lawyers or consultants to come in and look at your books for you. So that's very much along the lines of the work we do in the region.
Yeah, I'd maybe just echo that, Steve, because you know, one of the key drivers for the push for governance is the fact that on a global level, the regulators are much more active. So the US regulators have led from the front, but it's now moved into modern 10 jurisdictions where the international enforcement of the legislation extraterritorially is happening. And unsurprisingly, the regulators are all talking together and they're communicating and working together, which has been a big change over the last 10 years or so. You only have to read the news any day of the week and you'll see any of the recent news stories around settlements that have been reached in relation to principally corruption, but also sanctions. Invariably, it's a number of regulators and enforcement agencies working together. So it's something that you have to do as an organization. You can't avoid it. And doing it in a proactive way means you've got control over it. And it means that if you document it, you say what's happened, you say what you've done, that's your first line of defense. So that's where the good governance helps you hold off any accusations that you haven't done things properly. And it doesn't have to be all singing, all dancing, you know, gigantic, a huge exercise. It needs to be fit for purpose depending on your organization, where you're working and what you're doing. So it's absolutely fundamental to be thinking about this in advance, and it should just be sort of come as a second nature for organizations. But that historic thing that James was referring to in terms of the way things have worked here for the last hundreds of years, sometimes creates a clash between cultures, and that's something that I think we can certainly talk about, maybe navigating that a bit, because I don't know if you've seen it, James, but or anybody else, but one of the things I've seen is it's easier to talk about these types of structures where you're dealing or working with an international client, but it gets much more tricky when you're working with a client that it exclusively has their management from this region and has not come across some of these types of issues previously. That's something that we've certainly seen as being a more challenging environment.
Yeah, I think that's right, Adam. And I think that what we see a lot is, and I'm thinking really about where we're at in Saudi Arabia at the moment, is a lot of the strategic thinking has happened in Saudi Arabia. A lot of the operating model has been implemented, and they've set the governance structures, the policies and procedures, and now we're at a stage where how do we make it work? How do we implement it? It looks good on paper, but we're struggling to actually make it work. Can you help us do that? Can you help us really transform the mentality in the business and at all levels of the organization? Ali, how does this, from a diligence perspective, how do you look out for potential weaknesses in governance structures? What is it that you need to be mindful of?
Yeah, look, I think this focus has, I would say, transformed over the years when it comes to diligence, and it's now morphed into what we practitioners call ESG due diligence. That's just become a service in its own right. Previously, a couple of years ago, it just used to be something that would be looked at as part of your operational diligence, maybe a bit in the legal diligence. But now it's almost a work stream in itself. That's become a massive topic for investors and LPs. That's one of the big things anybody is now looking at. It's almost become a requirement for most funds. So when they're going out to raise money, every LP will ask, have you looked at the ESG status of the company and whatever you have in the pipeline? So it's now almost become a standard to do a diligence on the ESG side of things, and we're starting to see a lot more of that in the Middle East as well.
And specifically then on the G bit, what are we looking for, and what gives you comfort when you're doing due diligence?
Yeah, look, there are different standards in place. So, for example, if you compare yourself to a London-listed company, there are very clear standards of governance that the stock exchange requires. US has its own requirements around corporate governance, and our local markets here too have those standards. And over the years they've been working hard to improve the requirements around corporate governance. So typically, you would start with that as a benchmark. What's best practice in the market is usually the bigger stock exchanges who mandate certain requirements around governance. So and it does vary. It does vary by region. There's nothing set in stone, but at the end of the day, we advise our clients on best practices, which we've learned from different processes of taking private companies public, which today are the most likely the best market practices available.
Yeah, and Steve, I mean, this is relatively old news in your market. So what do we do in the Middle East to catch up to standards that a lot of which are driven out of the US?
Yeah, look, I think the requirements are old news, but I think US companies also have a difficult time meeting what what most prosecutors or regulators would expect that they're doing. And I think that companies all over the world suffer from the exact same compliance fatigue, lack of resources, lack of knowledge on how to do things. And so, look, every time I wind up an investigation where Department of Justice or SEC are on the other side, they find something wrong, no matter what the company, no matter what the company is, whether it's something that requires a published prosecution is something different. But there's always something that they think you should have done differently. I think coming back to our topic, a lot of it really is around what a company does when there's a compliance failure, what a company does when there is something that went wrong, a deal that shouldn't have gotten done, a middleman that shouldn't have gotten paid. And so, to me, the evangelizing that the U.S. government has done, and what I think, and we also do, frankly, is to figure out how you meet your risk without overdoing it, but also certainly without underdoing it. So that if something happens, you have the right documents that you need in order to answer if a regulator comes either regionally or from another country, but also to remediate in a way that your company gets better over time, which is, itself is valuable. Frankly, as I always tell my clients, it's less likely that someone is bribing someone using your money. It's much more likely that your employees are taking your money. And so fixing your controls and learning how to do an investigation in the right way actually saves money in the long run. I think that's something that most of my clients are a little surprised by. But I think there are a few steps when I think about how to deal with risk that everyone could follow and would help get ready for sort of that knock on the door. The first is something that Adam talked about a little bit, which is to scope to risk. So if you have an allegation, you have to figure out obviously what happened in that case. But if you have a bad manager, if you have potentially bad policies, then you could have risk that's much broader than just the allegations in that case. So it's really figuring out the scope of what you want to look at. You always want to figure out what happened in that actual case, but is there something more that we should be looking at? The second thing is that certainly European and US and Canadian regulators all now expect that you use your accounting data in any investigation. It used to be that you just go interview people and sort of try to figure out what happened. And there was much less of a look at all the data that the company generates in the course of its normal business. That could be that's always expense data, but it could be sales data. It could be data about the margin that you're charging, because there are various ways to manipulate your deals to create slush funds that can be used for untoward purposes. And so there's an expectation now that you get in and use your accounting data. That's typically what we're doing. If we were work alongside someone like Adam, that's something that we do is pull the accounting data and try to bubble up transactions that look like they're potentially anomalous, take a close look at them. Locking down your documents obviously is important. The United States government has pretty forward-leaning views on things like ephemeral messaging platforms. They hate WhatsApp, and that came from my time in the office as a prosecutor. I mean, the reason we hate it is because it deletes, right? So that's their problem with it. But the view of a lot of sort of European and U.S. governments is that those are business documents. They need to be retained at least long enough to figure out what happened. And so I know WhatsApp is quite common in the region, and it's a way of doing business. But figuring out how to take that stuff and look at it and make sure that it's retained is interesting. And I think the last step is really to document what you found and then document your remediation. And this is where U.S. companies fall down all the time. And if they have subsidiaries in the region, or companies that are certainly unaffiliated with Western companies, are going to have this issue, which is you figured out what happened, you fixed it, but then you didn't write it down. And U.S. prosecutors and regulators are very fond of saying if it's not in writing, it never happened. So I think that there's a practice around how you document things. Your compliance program, to the extent you have a compliance program, just needs to generate more paper, generate a longer memory, so that you can defend yourself and also so you can learn from whatever happened inside the company.
I'd agree with that, Steve. Maybe I'll just pick up on that documents point. Sorry, James.
No, go for it.
I was just going to add on that the document point that you made, Steve. It's it's a huge issue around the use of instant messaging in the region, and it's a global issue. But one of the very, very practical things that organizations can do that they don't do is have an effective policy around who owns the devices. So many organizations still have a bring your own device policy to work, and they might have something that says you shouldn't use your own device for business purposes, but that's just not going to work. Every client that I deal with, I'm encouraging them, if they haven't already done it, you should only be issuing devices that are owned by the company. You should have very clear express consents in advance to be able to access the information on those devices, because otherwise the key information that you're going to need when something's go wrong just will be very difficult to access.
Yeah, I wanted to pick up on that point you said at the beginning, Steve, about value, and I think it goes back to what we were saying earlier about how to affect change and and how to see value in governance in rather than just a defensive reaction to receiving potential fines, but more as a proactive creation of value. And obviously, risk management structures have been evolving. The governance models have been evolving to change from that defensive mentality towards one of value creation. And well-structured governance, good governance structures, proactive investigation, all these things that we advise our clients to do, create efficiencies, create effective, clear leadership, ability to make decisions on good information, which all frees you up to do what leadership does best, is help grow businesses. And so I think that's the thing that needs to be stressed is the value creation that can be derived from improved governance, not just governance for the sake of governance to satisfy regulators, etc., but as a strategy that can help create sustainable growth for your business. And that's a mindset that needs to be adopted more thoroughly in this region. I think certainly we've worked with clients not just on investigation side, but on implementing governance structures, and that really is the key message and the key change in some of the fundamental governance structures that are being developed. We talked about the 3 lines model, which is now developing along those lines, which is how to use those to create value, how to elevate the position of a risk officer, a CRO, into the strategic decision-making part of the business, and how risk management becomes very much part of your strategy of the business. So big themes that I think are being developed, not just here, I mean everywhere. This is all relatively new, but still evolving day to day. So what sort of what if we look forward, what kind of changes, Adam, are being put in place in the legislative environment? What would you, I mean, there's been a lot of changes to anti-corruption, anti-money laundering laws, data privacy laws, bankruptcy laws. What do you think are some of the key changes that are being put in place to support this, the growth in the region?
The biggest one I've seen in the last couple of years has been all around structures to try and deal with anti-money laundering, and that's almost across the entire region. The governments are really, really pushing this, specifically in the UAE a lot over the last year, and I think that's been driven. If you go back to Ali's introduction and the diversification away from oil-based, all the major economies in the Middle East are very keen to elevate their position on a global scale geopolitically and get a seat at the top table. And one of the areas that they've been frankly criticized for when it comes to international sort of reviews of structures has been around money laundering. So we've seen some very significant changes in the region around the implementation on mechanisms that companies need to follow to ensure they comply with the new laws that you just mentioned. And it's not just a lip service, it really is a sea change. So I suspect that we'll see more and more investigations and prosecutions from the authorities relating to AML and fines for non-compliance. So that's one big area. In terms of the changes in the law of anti-corruption, relating to anti-corruption, the big changes have been mirroring some of the changes that you've seen around some of the other major economies in the world and extending the scope of bribery legislation into the private sector. And that's a huge thing because so much of the issues that go on in commerce and business are not exclusively in the public sector. There's obviously issues there and there are risks. And the FCPA that Steve's talking about, that focuses on public sector rather than private sector. But for example, the UK Bribery Act doesn't. It has offences relating to both the private sector and the public sector, and so do the laws broadly across the Middle East. They include private sector bribery as well. So I think a lot of people have operated in this part of the world from a position where they didn't feel as if there would be domestic enforcement of the laws that existed, or the laws weren't that sophisticated or onerous. And the big sea changes that we're seeing are that's gone out the window. The laws are getting much more sophisticated, much more updated. They're being brought up to date to try and address the realities of how commerce is done with regard to data protection, with regard to electronic transactions and the like. And the regulators and the prosecutors are out there actually enforcing. I mean, probably the best example of that is the Saudi anti-corruption authority, Nazaha. They are incredibly active, not only in publishing information about the investigations that they're involved with, perhaps not in the level of detail that you'd see in European or Western organizations, but a lot of information is out there about what they're doing. It's very public. They're actively seeking information from the market, putting out requests via SMS text messages to the populace, asking for information about criminal activity that people are aware of. So actively encouraging whistleblowers to come forward. And that's just something you wouldn't even contemplated 5 years ago. And a lot of this is obviously driven by the way that the ruling families across the region are genuinely trying to change the way that some of these cultural norms for years and make it become a more level playing field for everybody, because for all the reasons we've talked about, you can't operate in a silo and bury your head in the sand and think that we can just go on the way we were, because people won't invest. People will have their confidence undermined, and in a global market where you want to rise up the pecking order in terms of successfulness of a jurisdiction or a region, you've got to change. So I think they're the main changes.
And actually, Adam, you brought up whistleblowing. We had a question from the audience, someone from South Africa, where the question was based on how whistleblowers can and should be dealt with.
Sounds very ominous.
In a rather abrupt manner. I think I was reading from the question, which seemed to suggest that in South Africa they're dealt with in a rather abrupt way, and so that's hence the abruptness of my question. What if I were to rephrase that? What is the sort of legal structure around whistleblowers and the defending whistleblowers in this region?
Sure. So I mean, maybe dealt with isn't a bad sort of colloquialism to use, because historically there haven't been many protections for whistleblowers in this region. It's certainly changing, but it hasn't changed. And there have been some new whistleblower protections in various jurisdictions, but they're not well known, they're not well used. And frankly, one of the big issues that organizations have is trying to encourage their employees, because it's invariably their employees that are the best source of information about where there are breakdowns in the governance structures, or individuals or customers or anybody that you're doing business with isn't doing what they should be doing, and the company would want to know about it. To try and encourage whistleblowers to come forward is a challenge in this region, and it's driven, I think, in part because there has historically been instances where there's been victimization. So where that is the case, you have to ensure that you've got a corporate culture that absolutely does not tolerate that, and you have to be seen to be making sure that you don't let that happen, because otherwise whistleblowing policies and programs just are pointless because they're not going to work. Another big issue that I see in this region very, very regularly is around the fact that the working population is very extensively expatriate. So that means people come in from outside the jurisdiction, obviously, and that can create situations that we see repeated time and time again, where when organizations don't have a good governance structure and individuals or departments are able to make their own decisions around hiring, you get enclaves where particular groups of individuals from particular jurisdictions tend to get recruited, and that creates like mini fiefdoms where individuals aren't then as willing to step outside the controls that perhaps their friend from the same part of the country that they've come from has secured the job from them. And you get an organization within an organization that is a fundamental breakdown in the ability of any commercial organization that wants to operate effectively from having controls that actually work in practice.
Really quickly, this is
Yeah.
Steve. I'll just kind of jump in on this. I think on the culture of whistleblowing, and I think it is hard to figure out how that culture spreads into places that are not used to it, and that's not just in the Middle East, but France, right, has no history of protecting or encouraging whistleblowing. But I think from a real politic perspective, if you're inside a company, I've worked with a lot of whistleblowers. I've dealt with a lot of cases where whistleblowers were the reason we were doing our investigation. And there's a psychological aspect to whistleblowing that is really critical to understand. And I think that I think a lot of business people haven't taken the time to think about it and really understand it. But a lot of times a whistleblower is someone who wants the company to become better, sees something where the company is leaking money or has a bad governance structure that in the long run is going to cost it money. And so the idea that anyone sort of retaliates against that is kind of wild. But in today's climate, where international publications are so very interested in salacious details, if you do not deal with a whistleblower internally, encourage them, report back to them, let them know that they were heard, you're going to see your documents splashed on a front page somewhere. That's just the way things are now in a way that they didn't used to be. And so I think that companies that are really forward-leaning are encouraging internal whistleblowing, right, and discouraging still external whistleblowing, which I think is fine. You can't prohibit it. In the United States, it's illegal to prohibit it, but in Europe, in many places as well. But I think that there needs to be a complete sea change in mindset about how to deal with these kinds of complaints.
Yeah, there was a question specific to whistleblower protection laws in Europe, and whether countries are ready to deal with this law as the deadline fast approaches. Adam, I don't know about this deadline. Do you know this? If you know the answer to this, then answer. Otherwise, we can move on.
Yeah, no, it's a big sea change in Europe. There's a whistleblower directive that's just come in, and then the organisations have a certain amount of time to comply with it. The short answer is I don't think companies will be ready. If you want to know what the laws are and how it's been dealt with, DLA Piper's just published 3 or 4 weeks ago a guide which is available freely on our website, which summarises the law and the way it's been introduced in each of the European nations. So don't ask me what the way it has been implemented in Germany or in Spain, but it's available on our website. So I'd check in there. But I think, frankly, organizations that are big and global or regional tend to have policies around whistleblowing and around managing them and protecting people. But it's the outliers, and it's how to actually put that into practice. Because I think it's one thing, as you were saying earlier, Jim, it's one thing to have the policy, but it's actually walking the walk and showing your employees that you do not tolerate retaliation, that you do actually follow through with your policies. And the only way that I've seen that done effectively is when you have communication actively from senior management demonstrating that they believe in this, demonstrating that they follow through with it. Because if you don't have that, and what the general populace of the workforce sees is silence from management, or frankly, policies that aren't followed through with, then there's no point having a whistleblower policy. There's no point having a program in place there. And it doesn't then give you what it really helps, which is give a front line of defense for when anything is potentially going wrong. You know, your ears and eyes, the workforce, and so you've got to have that to make it work.
Okay, I'm gonna thanks. I'm gonna put this question to the panel, and again we'll see who's got an answer for this one. So there's a question: what, if any, behavioral science-based steps can be undertaken by entities to promote a culture of compliance? Steve, is this your sort of PhD paper in the making? Is that something you think you can have a go at? Or
Could you repeat the question one more time, because it's pretty nuanced?
So,
behavioral.
what, if any, behavioral science-based steps can be undertaken by entities to promote a culture of compliance? I mean, I guess so. This goes, and there's a couple of other questions here. Again, it goes back to the cultural issue here, and I think we've already mentioned that is such a huge, in some cases, impediment to implementing the sort of governance structures that we've been talking about. And so, and we had another question about how the tribal system, what impact that has on governance, given that corporate governance codes are developed from US, UK systems, which have very different.
Yeah,
so,
I think, look.
Yeah, go for it, Steve. Give us a
No, this is something we deal with in every company. We do a lot of compliance consulting, and it's very correct that the U.S. culture on management is much different than, say, German culture or French culture or Middle Eastern culture, certainly Chinese culture. So it is something you have to account for you know, the cultural differences. But I think the main thing that is, for me, that drives culture is sort of a speak up culture, which is if you see something wrong, you have to say something about it. And that is more difficult in other regions. In China, that's nearly impossible, frankly, to implement, because there's just this, you know, the face-saving culture in China is very difficult to deal with. You know, getting people to speak up against management or point out that something went wrong. And so it's something we deal with everywhere, but you have to encourage your employees when a control is violated to take a close look at it. But frankly, one of the ways that we implement compliance programs is to sort of try to avoid those issues by putting enough controls in place that enough people will look at the same transaction, that there's no one single point of failure. And so, because if you're relying solely upon someone to say, I took a quick look at that and it looked wrong, then there are cultural drivers of not offending your coworker, or not being the squeaky wheel, or not being ostracized. If you go back to what Adam was saying about whistleblowing culture. But if it's more automated, if you have the right delegations of authority, meaning the right people look at larger transactions, and then there's, you know, an internal audit process of some sort of look back process, and all that's formalized, I think you avoid some of those cultural issues, because, you know, it becomes someone's job to point out that it didn't happen the way it was supposed to happen. Yeah, I know that's my take, is to largely sort of avoid the cultural nuances by making sure you have, you know, what I acknowledge are sort of Western style controls over financial transactions.
Yeah, I mean, I guess here the issue is the bypassing of those controls, and the deference to leadership, to stakeholders, to owners, at the expense of your own job description and the controls that you are there to follow. And obviously there's a lot that we've learned, and I think it's you know, people at all levels kind of need to the companies, organizations need to really define their values and align those values with that set of systems and with individuals' values, so that it becomes more standard practice. It becomes less acceptable to circumnavigate those controls. Easier said than done. So guys, we got about just under 10 minutes left. I thought maybe we just wrap this up. If just going around and saying, what your advice to your clients are within the context of the topics we've discussing. Ali, bringing it back to you. What are the key things that you're telling your clients when they're looking to invest in this market?
Yeah, look, I mean, like I said earlier, ESG with the G is being a very much a focal point for any investment that comes into the region is definitely something we advise clients to look at. There are diligence frameworks developed to help them through that. So that pretty much happens on every international transaction we work on. AML, to Adam's point, is also important consideration. So we see a lot of the international investors focused on diligence around AML and what we call ABCD, which is anti-bribery and corruption diligence as well. So there's a range of measures which international investors are taking when they look at investing out, in let's say emerging markets. So I think it's good diligence will save a lot of pain in the future, and and then post transaction you would want to implement structured governance and make sure that the management adhere to that, and put in processes in place where you are monitoring compliance to corporate governance on a regular basis.
Adam, your thoughts?
Just listening to what Ali's saying, then I'm just sort of thinking, much of what you said is similar to what I'd be looking at from a legal perspective, but I think maybe the slight additional points would be around trying to change the mindset of clients so that they appreciate that if you spend a little bit more time at the outset in making sure that you're proposing to get into business with the right person, you think a little bit longer about the corporate structure that you're going to market with, that you document your arrangements with your counterparties with a little bit more forethought, that doing that at the outset really is good governance, but it's prudent from a business perspective, because it's so easy for things to go wrong in a business organization when there's a myriad of factors that are outside of your control. And in all of the instances where we get involved retroactively with an investigation, some of those things haven't been done properly. The organization hasn't thought about the risks. It hasn't realized that it could have done things differently. And I think that's probably the main thing that I take away in terms of what would I tell clients. It's just stop, slow down, step back, and have a little bit more forethought around what could happen in 1, 2, 3 years' time.
Steve, let's wrap up with your thoughts.
Well, I think Ali and Adam put their fingers on it, right? I mean, in the region, I think that at least my perception, the perception of prosecutors here certainly, is that counterparty risk is what's really driving a lot of your issues. And I think that again, coming back to sort of reemphasize something Adam said earlier, I just don't think you can set up a structure and let it go for years, right? You can't use the same counterparty for 15 years. I've seen repeatedly in investigations in the region where management of a counterparty changes, ownership changes, and no one takes another look at it. And there's just sort of this is how we've always done it thing. And that's not unique to the region. I'm dealing with I have cases in Latin America where you see sort of similar arrangements. I think, periodically looking back at who you're doing business with and the structure of how you pay them is incredibly important. And if you can move away from things like success fees and contingencies and some of the arrangements that have really driven problems in corruption cases around the world for years, that's something to try to do. As sort of the business practices mature, if you can be on the leading edge of joining that maturity, I think that it is certainly a helpful thing.
All right, well, thank you, everybody. Thank you to all our attendees. And we will speak again soon, gentlemen. Thanks all for your time.
Thanks, James. Thanks, John.
Thank you.
Speak soon.